this is the continuation of the Contract Act what we have discussed in the last class, because this contract of indemnity and guarantee, it is a special type of contract as well as it is a species of general contract. So what we were discussed in the last class, that is all a general contract, that is the basic principle of general contract. So in order to satisfy this contract of indemnity and guarantee, all the general principle of Contract Act must be fulfilled. That means section 10 of the Contract Act must be fulfilled before we entering into a special contract. But what section 10 says? Competency of the parties, lawful consideration, lawful object with a lawful consideration and object, and competency, free consent, all must be present in the contract of indemnity also. But only because it is a special type of contract, only change in this indemnity is that it is the person can take the damage or can be compensated if he has suffered any loss, especially in the form of promise to pay. That means if a person suffered any loss and the other person promised him to make good the loss, it's an example for a contingent contract what we have studied in the last slides. Contingency means if the performance of the contract depend upon the happening or non-happening of a particular event, future event. Nobody knows what happened in the future. Suppose if the contract takes place to do or perform a particular act and the happening or a non-happening of an event, it is nothing but a contract of indemnity and guarantee. So as per the section 124 of the Indemnity or the Guarantee Act, what is an indemnity means a contract by which one party promises to save the other from the loss caused to him by the conduct of the promiser himself or by the conduct of a third party. That means making good the loss to the sufferer by the other party. Here there are two parties, one is suffered loss and the other person promised him to make good the loss. Say just as a contingent contract or in a contract of insurance, if the insurer assured the insurer to compensate him for the loss caused to him. Say for example in case of life insurance, if a person dies, or if a person in case of health insurance, if a person have suffered any loss because of his illness, so whatever the loss caused to him because of the treatment, that will be compensated from the insurance company, because the insurance company has promised the sufferer to make good the loss. That is nothing but a contract of indemnity. So being a contract of indemnity, it is must fulfill all the essential element. That means parties must be major, must be competent, consideration must be lawful, object must be lawful, and consent must be free. So there is an implied promise to indemnify an agent by a principal. It is not only contract of insurance but also contract of agency. In case of contract of agency, an agent will be appointed by the principal. So whatever the act that is done by the agent, that will be indemnified by the principal. That means act of the agent is as good as of the act of the principal. So whatever the act done by the agent, it seems to be an act done by the principal. So any contract of agency is nothing but a contract of indemnity. And insurance contract is also a good example for this. So in nothing less, how a contract of indemnity happens, what is the things that is to be done in the contract of indemnity is same as that of the General Contract Act. Only thing we have to look into this is what is the right of an indemnity holder. So the person who indemnifies the person is called an indemnity holder. That person for whose on behalf that indemnity has been done, he is called as an indemnifier, and the person who promises to make good the loss is called as an indemnity holder. So in such cases, what are the rights of an indemnity holder? So an indemnity holder, after making the payment of the losses or the damages, he can compensate all damages which may be compelled to pay in any suit. Say for example, if he has filed a suit, some amount must be reimbursed, that indemnity holder is entitled to have that money, and all costs he may be compelled to pay in any such suit. So if any indemnity holder has suffered any loss or he has paid any cost for the proceedings of the court, or in any case, in such cases he can be take the amount from the indemnifier, and which may be paid under the terms of a compromise of any suit. If the suit is compromised, so if any cost incurred for the compromise petition, in such cases indemnifier has to reimburse it to the indemnity holder, and no action could be brought against the indemnifier until he has suffered actual loss. That is the only difference between the contract of indemnity and the contract of guarantee is, in case of indemnity, only the compensation can be given if he has an actual loss. Only the person has suffered the actual loss, the indemnity takes place. And the parallel contract is the contract of guarantee. Contract of guarantee is nothing but the contract to perform a promise made or discharge the liability incurred by third person in case of his default. That means contract of indemnity is the indemnifier will be make good the loss, or he will be compensated if the actual loss is made, and the indemnity holder will give the actual payment. But in case of contract of guarantee, before actual loss is suffered, the other party assured the principal debtor to compensate the creditor. So it is nothing but a contract to perform the promise or to discharge the liability of a third person in case of default. That means it's a contract for guarantee. There are three persons. One is the principal debtor, and other is the creditor, third one is the surety. Here the debtor has took some loan or make some liability with the creditor. The surety will stand between the principal debtor and the creditor to make good the loss to the creditor on behalf of the principal debtor. So in case of it incurred by the third party in case of its default, if the principal debtor fails to pay the money to the creditor, then the third party, the surety, will give the payment. So implied promise by the principal debtor, that means if the principal debtor takes some credit from the creditor, and the surety will stand in between, if the creditor fails to pay that amount to the creditor, the surety will pay the money. In all these contract of guarantee, the first liability is always on the principal debtor, and the second it is the of the surety. So what are the features, essential features of contract of guarantee? Contract, it may be oral or writing. It is best an example for this contract of guarantee is the bank loan. If a person want to take a loan from a bank, the bank always asks for a surety. So he has to sign on some of the documents. He stands in a fiduciary relationship with the creditor as well as with the principal. So it contract may be in oral or in writing. In most of the cases, contract of guarantee is always in agreement in writing, and there should be a principal letter who owes money to the creditor, and always this benefit to the principal debtor, because surety will not gain anything, no consideration to the surety, only consideration is the benefit of the principal debtor. If the principal debtor has not failed to pay the money, surety will give. So whatever the money will give to the creditor, that itself is the consideration for the surety and that benefit to the principal debtor. And consent of the surety should have been obtained not obtained by misrepresentation or concealment. That means consent of the surety must be obtained with free will. No coercion, fraud, misrepresentation has been done on the surety to accept as a surety. So, if the surety without any advantage or without any gain, why he has to stand as surety for the principal debtor? Because surety, what is the liability of the surety is that same as that of the principal. It is not that surety is doing his work freely. Suppose if the surety pays money to the creditor, then whatever the amount that a principal is entitled to, that surety will entitled to have that. That means after payment to the creditor, surety will step into the shoes of the principal debtor. So whatever the money, whatever the thing, whatever the security that debtor is liable, surety will entitled to have that. Discharge from surety. Not necessary that surety is always stand as a security for the principal debtor. If any act or any misconduct on the part of the principal debtor will discharge the surety. So under what circumstances surety can be discharged from its liability? First is it is varied without consent of the surety. Suppose if a principal debtor make any new contract or gives any new term in the contract without consent of the surety, then surety will be discharged. Then if the principal is discharged, so if the creditor discharges the principal debtor, then naturally surety is also discharged. So it is a contract between the principal debtor and the creditor. Suppose without consent, without knowledge of the principal debtor or the surety, if the new agreement between the debtor and the creditor, surety will be discharged, or any act or omission result of which discharges the principal debtor. If any creditor makes any misconduct, in such cases that principal debtor will discharge, similarly surety. That is the first right of the surety against the principal debtor is the right of subrogation on payment. That means if the surety make payment to the creditor, then whatever the rights which is availed to the principal debtor, that surety is entitled to that. Secondly, so whatever the securities that benefits the principal debtor is made available to the creditor, that the surety is entitled to have that security. Say for example, if the principal debtor put anything as security with the creditor, after payment of debt to the creditor, surety will entitled to have all the securities in his name. Thirdly, he is entitled to recover from the principal debtor whatever the sum he has paid. It doesn't mean that if the surety pays any amount to the creditor, he suffered loss. So any loss suffered by the surety, he can entitled to avail it from the principal debtor. That means principal debtor is not discharged if surety has made payment to the creditor. So if the surety gives payment to the creditor, afterwards that principal, that surety will entitled to get it back from the principal debtor. Now there are similar types of contract. These two contract is, one is the contract of indemnity and second one is the contract of guarantee. What is the difference between these two? First thing is, in contract of indemnity only two parties, in guarantee there are three parties, and only in the object of this contract of indemnity is making good of the loss or reimbursement of the loss suffered. Here it is only security for a debt. So security will be given before debt is made. Here in case of contract of indemnity, only that obligation arises after the loss is suffered, and liabilities of the indemnifier is primary. In case of contract of guarantee, liability of the surety is secondary, because if the principal debtor will fail to pay the money to the creditor, the creditor will first sue or ask the principal debtor to pay. If the principal debtor fails to pay, then only rights of the surety will be, liability of the surety arises. Here, that's why the liability of the surety is secondary. Here in contract of indemnity, there is only one contract. In guarantee, there are three contracts. Contract between the creditor and the debtor, creditor and the surety, and the principal debtor and the surety. Three types of contracts. And in case of contract of indemnity, it is not necessary that debtor request is necessary. Debtor himself promises to pay, but in case of contract of guarantee, request will be made by the principal debtor to become a surety. So, request is always necessary in case of contract of guarantee. And in case of contract of indemnity, there is no existing debt at the time of entering into the contract of indemnity. But in case of contract of guarantee, there is already an existing debt. And lastly, no right to sue. Indemnity holder cannot sue the indemnifier, but in case of contract, surety has a right to sue the creditor. And lastly, rights of the surety, rights against the creditor, rights of the surety against the debtor, and rights against the creditor. First right is when after payment to the creditor, he can ask the principal debtor to pay the debt. Secondly, principal surety cannot be called to make the payment before calling the debtor. Secondly, on being sued by the creditor, if the creditor sue the surety to make the payment, then any counter claim against the principal debtor, the surety can rely on any such counter claim. Then surety can get into the shoes of the principal debtor after payment, and surety is entitled to the benefits of every security. That means whatever the rights of the principal debtor, that can become a rights of the surety after making the payment. Rights against the principal debtor, that is the right to relief from liability before payment is made at any time. Suppose if it is surety is for a one act, that liability cannot be discharged, but surety is for a continuous period. So at any time, if the surety wants to discharge from his liability, he can be discharged. In every contract of guarantee, there is always an implied promise by the principal debtor to indemnify the surety. Then rights against the co-sureties. In any event, there may be more than one co-sureties. So, if all the co-sureties are entitled to contribute equally for the payment, if there is an agreement, in such cases, the co-sureties have to pay equal to their shares, and they can also reimburse it from the principal debtor according to their shares.